Good morning, everyone. On behalf of the US-Mexico Chamber of Commerce, I would like to welcome all of you, members and friends. My name is Clementina Gay, and I'm the Executive Director of the Inter-American Chapter. As all of you know, the US-Mexico-Canada Agreement became effective last July. This treaty shaped the future of trade in North America. The agreement contains significant improvements and modernized aspects such as rule of origin, customs administration and trade facilitation, intellectual property, digital trade, financial services, labor, just to mention some of them. This morning, we asked a group of experts to share with us their views of how they foresee the implementation of the new agreement and the impact in the North American economies. Our main goal will be to discuss how the private sector can take advantage of the agreement, how to follow and comply with all of the new rules, and how the market participants can become more competitive and make the right decisions to improve and develop their operations and results. Our topic today is USMCA, new technologies and best practices for investment and trade. Before we begin with all the information our panelists have prepared for us, let me introduce our guest of honor, Consul General of Mexico in Miami, Jonathan Chaid Auerbach, who has been an unconditional supporter of the Inter-American Chapter. Thank you, Jonathan, for accepting this invitation and for your tireless commitment to promote and empower Mexico here in Florida. Consul General Chaid will give us a few words.
Thank you so much, Clementina. The honor is mine, and thank you for having me here. So good morning, everyone. It's an honor to welcome you to this very relevant webinar that our friends of the Inter-American Chapter of the US-Mexico Chambers of Commerce have organized to further understand the remarkable opportunities that USMCA offers, particularly in issues such as new technologies, customs administration, rule of origin, labor, law enforcement, and investment protection. I especially want to recognize the work of the President of the American Chapter, Antonio Peña, and its Executive Director, Clementina Gay, for giving me this opportunity to be with you. The high quality panelists that are participating in today's webinar will bring their expertise to the table to further deliver in these matters. I want to briefly give some statistics of the relevance of North America trade and why I consider the recent adoption of USMCA includes key provisions that foster opportunities to boost the economy, particularly during the pandemic. Mexico is the top US trade partner ahead of Canada and China. The North American region has accounted for a total trade of $1.26 trillion in 2018, with a combination population of 495 million people and combined GDP of $23 trillion, representing almost 30% of the world GDP. Also, 12 million US jobs are supported by trade with Canada and Mexico. Consequently, Mexico is the second largest trade partner of different states of the United States. It surpasses the $10 billion exchange in 2019 that employs around 314,000 people in this state, with 8.5% of state imports coming from Mexico, mainly in ground, air, and maritime vehicles, machinery, and agricultural products, whereas 5.9% of Florida exports are directed to Mexico, being machinery, ground, air, and maritime vehicles, and chemical products, the most exchange between Mexico and Florida. Prominent Mexican firms have also invested in the state, like Grupo México, Grupo Posadas, Chedraui, Cemex, Televisa, Softec, Bimbo, just to mention a few of them. Moreover, advantage may be taken to this commercial potential by using maritime routes. For instance, more than 50,000 autos were traded with Mexico through Port Everglades in 2019. Although port commercials has grown in the past 3 years by 40%, the majority of Mexican imports still arrive by land. Taking this into consideration, the consulate has been extremely active to foster the issue through a series of negotiations that in 2020 culminated in the creation of Mexico-Florida Working Group to boost nautical commerce. In the economic arena, this has been one of the most important priorities for the Consulate of Mexico, and we'll keep updating you on the developments on this matter. In a time where COVID-19 pandemic has had an impact in some local economies like the hospitality industry, services, tourism, and entertainment, we also have found opportunities in some sectors. Thus, the entry into force of July 1st, 2020 of the USMCA, after a successful negotiation, comes at a decisive time, since commerce is one of the major motors of economic growth. Deepening integration will also serve as a powerful tool, starting historic new chapter for North America with a common vision of free and fair trade for the future. Technology has reconfigured our life, especially during the sanitary crisis, and it is critical to boost economic recovery. Digital commerce, it's become a new normal in Mexico. In 2019, digital commerce grew 29% in our country, and in the first half of 2020, transactions were above 40% that in the same period that previous year in 2019. This new USMCA chapter will allow for firms of all types and sizes to freedom to move data across borders and prohibit the forced location of data, ensuring innovation and the continued growth of this dynamic sector. After more than a quarter of century promoting free trade, supposedly integrate no final product in just Mexican, American, or Canadian, rather 100% North American. We don't just sell to each other, we build things together. Country rules of origin have been strengthened to support competitiveness in the region and build regional values of chain. For example, some automobiles, most of 75% of their component manufactured in Mexico, the US and Canada to qualify for zero tariffs. It's at the safest moment to strengthen the productive integration of North America and boost new regional value chains to replace import from outside the region. In addition, USMCA key provision reflects more inclusive and responsible trade deal that aims for a spillover effect that benefits everyone from free trade. It is the first in its kind to include elements that address the social impact of international trade, such as environment protection, rules, and anti-corruption, and enable the participation of a broader range of sectors in the economy, for instance, with the gender equality provisions. I'm concluding with this. USMCA brings opportunity to enhance our competitiveness and foster regional growth, particularly during the pandemic. In this uncertain time, the greatest asset is bringing the certainty and clear rules to provide to the business community and all the actors involved. I appreciate this time and opportunity to address this audience, and please do not hesitate to contact us, and we are happy to continue working with all of you. Thank you.
Thank you, Jonathan. Thank you very much. I appreciate you are always with the chamber. Thank you. I would like to give a special thanks to the U.S. Customs and Border Protection, the Florida Customs Brokers and Forwarders Association, and the Miami-Dade County International Trade Consortium for the support and promotion of this event. Now is the time to pass the microphone to our leader of the project, Turena Ramirez, partner of the law firm Sanchez Devanny. Turena is the head of the International Trade and Customs, with more than 17 years of experience advising companies on cross-border transactions. Turena, it has been a pleasure working with you in this project and with the whole team. Let me mention super quick, if you have questions during the presentation, please send them to the chat. We will try to cover as many questions as we can at the end of the webcast. Well, so Turena, please, could you help me to introduce our panelists?
Thank you very much, Clementina. Thank you to the U.S. Chamber of Commerce for this opportunity. And thank you all for being here today with us and be able to, to have this opportunity with these high-level panelists that we are going to have a pleasure to discuss main topics of the USMCA today. As Mr. Chai has explained, with its 128 million people and a GDP of 1.26 trillion, Mexico is strongly connected with the United States geographically and of course through commerce. What happens in Mexico directly affects the security and the prosperity of the United States and vice versa. Mexico, not China, is now the United States' largest trading partner, and this interchange will be reinforced now with the implementation of the USMCA, which feeds and will be fed by an enormous US investment of around $101 billion in 2019, according to the US Department of Commerce. So this is mainly the reason why we needed to have this new free trade agreement in place. The USMCA, as we have heard, exposes a lot of new conditions there are over 12 chapters that were actually new from the Nafta to the USMCA. And it actually imposes also the responsibility for countries and for multinational business doing business in the region to know and comply with the new rules of origin, with the new conditions, with the new labor requirements. And of course, it would be very important for you to understand what are the benefits that you can take advantage of by using this USMCA now in your full operations. So today we have the pleasure of having as a panelist, Mr. John P. Leonard, which is the Executive Director, Trade and Customs Policy and U.S. Customs and Border Protection Agency with the headquarters in Washington, D.C. Fanny Euran, who has 20 years of service in private and public practice, and she was actually a former high-level authority at the Mexican Customs, and now she is partner of the GBC Global Business and Solutions. Adrian Correa, from our private sector speaker, which is a Regulatory and Government Affairs Senior Advisor at Federal Express, the Division of Latin America. And Ricardo Ramirez, who was actually the first Mexican to be appointed to the appellate body of the World Trade Organization from 2009 to 2017. And now he is partner at RRH Consultores in Mexico. So welcome you all. And I would like to start with you, Mr. Leonard. If I may, I would like to ask you a question. The transition from Nafta to USMCA has been a large undertaking. And what are some of the U.S. Customs and Borders Protection has done to ensure like a smooth transition? We would love to hear the U.S. authority perspective in this sense.
Thank you very much, Tirana, and great to see everybody, and thanks for joining today's webinar. So U.S. Customs and Border Protection has put a lot of resources into implementing this trade agreement and making resources available to the public, in particular, making use of technology to do that. So obviously the USMCA replaced the 25-year-old Nafta agreement, which we were all very, very used to working with. Many of us grew up our careers around the Nafta and got to know its policies and rules very, very well. And so USMCA, while it kept a lot of the Nafta rules of origin and other aspects, quite a lot had changed as well. And so CBP really leaned in on making sure that private sector stakeholders would have the ability to get the information they needed. So we've put out quite a few innovative technologies. First of all, we've got a chatbot on our website. It is a AI-powered device that basically answers your question. Hopefully some of you have seen it by now. Very easy to find just by going to cbp.gov and our trade section. You'll see it'll pop up at the bottom left-hand corner of your screen, and you can ask it a question. And over time, since we've entered into force on July 1st, the chatbot has answered literally thousands of questions, and due to the artificial intelligence, it actually gets smarter with each question it answers. So by now, hopefully, if you pose a question, it'll be able to actually answer it. So that's a great feature. The USMCA has also been incorporated fully into our single window, which is the automated commercial environment. The single window is actually part of the agreement. The USMCA encourages and requires use of single window by the parties. And we've also, in addition to the chatbot, we've enhanced the website to include a portal for automotive goods certifications and a targeted inbox for inquiries. So the trade that's involved in the automotive area can actually submit required documents through the portal. So somebody has asked about the website, and I'd be happy to repeat that. It's very simple. It's just www.cbp, right? Like Charlie Bravo Papa, .gov. That gets you to Customs and Border Protection's main website. And then if you just simply click the trade section, you'll come right to our area that deals with international trade, and the USMCA is prominently featured there, as well as the chatbot. So I hope that you all take advantage of that. The other big thing that we did in terms of leaning in on this mammoth free trade agreement, the US's largest free trade agreement by far, is we stood up the USMCA Center. So that is a dedicated center that's under my portfolio. We've got about 8 full-time personnel that actually do nothing but USMCA management, getting word out, getting policies out. It is really the one-stop shop for questions concerning the USMCA. Very easy to get in touch with them also by that website, as well as by email. So that's also very simple email. It's just usmca@cbp, Customs Border Protection.gov is how you can get in touch with them. So that staff is dedicated to getting questions answered on the USMCA. It's actually a physical location. I'm actually here right now at our headquarters office at National Place in Washington, D.C. And the USMCA Center has got a physical location where we all work. However, most of our staff now, of course, due to COVID, are working from home. However, the center is as active and as busy as it ever could be, even if we're here in person. And coincidentally, we actually stood up the center on the very day that CBP went to full-time or for our non-uniform personnel working from home, which was, I believe, March 12th. So that very day was when we actually stood up the USMCA Center. So we didn't miss a beat. The center has been very, very busy and active. And once we get past this pandemic, we'll all be physically located here at this building in Washington, D.C. So really, Terena have put a lot of resources into getting the word out about USMCA and encourage people to take advantage of that.
Well, thank you very much, John. I mean, we can definitely see a huge effort and commitment of the U.S. government in this regard. There is interest in the trade arena about the changes between Nafta and the USMCA in terms of compliance. Can you please highlight some differences and some specific, perhaps, concerns that you may have?
Yeah, I'd be happy to do that. If you had to pick one major difference, and there are, of course, many, especially in the automotive section, but the one difference that affects everybody is we no longer have a set certificate of origin. Okay, you all remember under the Nafta there was an actual certificate of origin. In the United States, it was our Customs Form 434 that the exporter had to fill out. And that was a form that many of us got very, very used to over time. And that was kind of a comfort zone, right? But now, because this is a modern gold standard free trade agreement, we no longer require a specific certificate of origin. So now it's not so much the certificate, it's the certification that is what needs to be done. So as long as you have the data elements that are outlined in Annex 5A, what we call the minimum data elements, available, you're good. As long as you can have those at hand if asked by whether it's CBSA, the Canada Border Services Agency, whether it's Customs and Border Protection or Mexico SAT, as long as you can produce those elements, you're good to go. Now we've kind of made it easy for folks to be able to put those elements together. We've actually posted a suggested template for the certificate of origin that is up on our website. Again, you don't have to use it. It's not a requirement, but if you feel more comfortable about having sort of a quasi form, this is available for your use. And it's right up on that website that I gave earlier, cbp.gov. In the trade section, you will see, and it's in PDF form. You can download it, very easy. Distribute it among your company. Again, if you feel you want to use that, again, it's not required, but the trade has told us that they find it very useful to have that if they don't want to create their own sort of database or form for the rules of origin. But you know, I'm sure later in our webinar we'll talk more about some of the automotive sections and different changes there, and with textiles as well. But that really is the biggest overriding change, is this notion that we no longer require a formal certificate of origin form.
And what about the automobile section and the sector that was, you know, very highlighted in all the press, and of course was a major interest for the U.S. government and the Mexican government as well. I mean, what would be like the most significant differences between perhaps the rule of origin compliance from Nafta to USMCA? What could be the impact?
Sure, yeah, and let's face it, right? So much trade between Mexico and the United States in the automotive sector. The little car that I drive, right? My Volkswagen Jetta was made in Puebla. In the Nafta time, right? I think it was. I have a 2017. So you have an engine manufactured in Germany, assembled in Volkswagen's plant, and there's so many other vehicles are manufactured in Mexico and come up to the U.S. So it's a huge deal. But the big differences really were, I could kind of describe them in three sections, Tarana. So we've got an increased regional value content, right? Under the Nafta, it was 62.5%, now going up to 75%. The labor value content, the LVC, was a major change. So 40 to 45% of the defined percentage of automotive imports by value must be sourced from high wage paying manufacturing facilities in North America. So essentially, your plant in Mexico has got to be paying 16 USD per hour at a minimum. Finally, a big change in the steel aluminum procurement area. 70% of the vehicle producers' annual purchases of steel and aluminum in the USMCA territory must be of originating goods. So three major changes in the automotive rule of origin section. Essentially, what they're doing is they're just making more requirement for more stuff to be done in the territory. It's a stricter rule, and a lot of people kind of have trouble wrapping their heads around that. You think a free trade agreement, you're going to relax rules, but the automotive was one area that the parties agreed we want to make this more North American content and labor and better wages for people. So yeah, those are the big changes in automotive.
And of course, it will represent a huge, challenge for the facilities in Mexico, but also a good opportunity because of the proximity requirement that we will need now for the compliance of the rule of origin. So we can expect a lot of innovation or European investment now in tier 1, tier 2, or tier 3 suppliers in the country. So yeah, well, thank you very much, Mr. Leonard. And talking about what could happen in Mexico, Fanny, you have had a lot of experience inside the Mexican customs administration. You have negotiated a lot of free trade agreements. So it is for us very important also to have your perspective now through your experience and your private sector advisory. And let me ask you this. What would you consider to be the most important provision in the USMCA Chapter 7 to streamline or provide a more competitive and efficient environment for trade?
Good morning, everyone. Thank you very much, Turena and Clementina, for the invitation. I would say that, as you all know, this is a new chapter. There was not a trade facilitation chapter on Nafta, under Nafta. And although the three parties are also a party to the WTO agreement on trade facilitation, what they did here is Chapter 7 resumes some provisions from the WTO TFA. But they increase the level of commitment, they increase the level of cooperation between the parties, they include additional measures, and they enhance some measures. And I think that's very important because it reflects the interest of the three parties to to develop a set of standards in the three parties to be more competitive in the region, as a region. They recognize that it's not only a matter of eliminating tariff and non-tariff barriers on trade, but also the customs process should be smooth in order to be to attract investment into the region. So, and obviously, it will not automatically streamline procedures, but what it does is it provides a framework for the parties to work in their domestic regulations, procedures among themselves, with other agencies, and with the traders to implement measures and initiatives to simplify procedures, to streamline procedures, to increase transparency, consistency, predictability, to be more competitive, more efficient, and more attractive for investment. And there's a couple of areas where I would like to mention a couple of provisions. The first one is, I think there's three provisions that are key to trade facilitation. And these three provisions are risk management, both for customs administrations and other agencies involved in the release of goods, trusted trader programs, and post-clearance audit. And these three provisions are key to facilitating trade without risking controls. By managing risk and using trusted trader programs, the customs administrations should be able to distinguish high and low risk shipments, and they should be able to develop and apply different approaches, inspection and enforcement approaches to each of these two different types of shipments. And in order to simplify the release of low shipment goods, focus inspection on high risk goods, and they are also encouraged to favor post-clearance audit, also on a risk-based approach, to facilitate and expedite legitimate trade, and to be more efficient on customs enforcement actions. And I think that's very important because the chapter covers not only the facilitation area on Section A, but it also has a Section B on cooperation and enforcement. The Chapter 7 also introduces new instances to ensure that all parties will have a better coordination and communication among themselves and with the traders. And there's a provision that states that the parties shall maintain a mechanism to regularly communicate with traders and provide them with an opportunity to raise issues, to present their views to their customs administrations on the customs procedures. And I think this is very important because the private sector has a very good, a very clear, a very deep idea of what is working, what's not working. So I think we should engage to help materialize the trade facilitation commitments made by the three parties under the USMCA. Also, there's a Committee on Trade Facilitation, which is the instance where the parties meet to exchange information, exchange experiences, discuss possible initiatives, define priorities, and work in order to implement measures, implement or develop initiatives to facilitate trade. And also they can discuss individual cases, pending cases, in order to reconcile inconsistencies. So, and also the parties are encouraged to provide opportunities to the traders to provide input matters to the committee. Through their customs administration, they may raise issues to the committee. And I think we should take opportunity of these two provisions to reach to our customs administrations, to bring forward issues, to propose items to be included in their agendas in order to improve our day-to-day operation. There's also provisions with regards, for example, to predictability and consistency, which I think is very important to have certainty. There's two provisions. One is advanced rulings, which are provided in the WTO, TFA, but also it's provided in Nafta. And the important change here is that it has a wider scope, as you know. It includes issues such as tariff classification, customs value criteria, and other issues the party may agree, and they should be made public by the parties. And I think this is relevant, particularly in the case of Mexico. I think people don't use this measure too much. People do not ask for advance rulings very often. And I think the best way to be sure you will not have problems later on your operations is if you upfront, before you start operating, you ask for an advance ruling. And now that we can ask for advance rulings, not only with regards to origin, but also with regards to value and tariff classification, I would urge everyone to do that, to be sure that you will not have surprises through once you have made your operations. It includes also an additional measure, which is not covered in the WTO, in the TFA, and it is the administrative guidance. And I think this is a very good measure. It provides traders with an opportunity to raise inconsistencies with customs headquarters. So this is aimed at making sure that provisions are interpreted and applied consistently throughout the territory of the parties. There's also provisions with regards to transparency. For example, the parties are both in the TFA and now in the USMCA. Parties should provide advance notification for comments for regulations they are going to publish, for changes to publications, which for the US and Canada is not new, but in the case of Mexico, Mexican Customs Administration is not required to publish in advance for comments or in advance prior to entry into force customs legislations, regulations, or procedures. So it may do so. There's a provision, but it's not mandatory. It's an option. So they may do that. They may do so, or they may not. And more often, they do not publish in advance for comments regulations. So I hope we will be able to work with Customs Administration, with the Tax Administration Service to get there, to make sure they do provide legally bounding basis for customs authorities to publish in advance for comments, at least customs administrative regulations as provided in the agreement. Of course, USMCA states specifically that according to their internal legislation, that if whenever possible, they should try to publish in advance. So it's not that mandatory, but I hope we do move there. And there's also a number of provisions to expedite procedures, including general rules for clearance, specific rules, initiatives. In the case of clearance, it provides for advanced filing of customs declarations, automated procedures, harmonization of data and systems among the parties. With regard to specific procedures, it sets standards for express shipments, low-value shipments, border inspection, transit of goods. And I think in general, it is a very ambitious framework for trade facilitation. It provides instances for customs administrations and traders to implement measures to provide for a competitive environment for trade business. So I think we should take advantages of this. We should engage with our customs administration and work to materialize these commitments.
Thank you, Fanny. And of course, a huge responsibility for the three-party authorities, and to be consistent to enforce these robust trade facilitation policies. And of course, let's hope that the Mexican authorities, have this type of interaction with the three parties, and be a facilitator in terms of not only trade but also in higher standards or policies. And talking about the new provisions in the USMCA, what would you say importers and exporters should know about these new provisions that could represent the risk for non-compliance? And a little bit, connecting the dots with what Mr. John Leonard explained about the rules of origin. I mean, do you know, what has the Mexican government, prepared for the compliance of, in terms of rules of origin, in terms of facilitation? Can you tell us about that?
Yeah, well, I would like to mention in this regard, Section B of Chapter 7, Cooperation and Enforcement, because it includes provisions regarding cooperation, exchange of information, and other measures among the parties to strengthen their enforcement efforts. And this is concerning customs offenses in general, including unlawful activities, including duty evasion, including smuggling, circumvention of safeguards, anti-dumping and countervailing duties. And it has a very wide scope, a very high level of cooperation between the parties. It includes exchange of historical data, exchange of data in real time, spontaneous exchange of information that might assist the party to detect, prevent, or address customs offenses, exchange of specific confidential information upon request, other forms of cooperation, such as creation of task forces, joint or coordinated data analysis, special monitoring measures. And there's particularly one provision that I think it's interesting, it's new, and it has a wide scope, and it is a new verification procedure. In addition to origin verifications, there's the customs compliance verification process. And I think it's important to be aware that under USMCA, a party's customs administration, or all the parties' customs administrations, are entitled to request customs compliance verification. And in this case, one party may request another party for assistance to determine whether a customs offense is occurring or has occurred, to customs offense according to its legislation, either by obtaining information, documents, or conducting on-site visits to exporters or producers in the requested party. So the requesting party asks the requested party to conduct a verification. This verification is aimed at determining whether a customs offense has occurred or is occurring. And the way to conduct this verification, as I said, is to request documents, information, or to conduct an on-site verification. The verification is conducted by the requested party in its territory. And as a result of this verification, the requested party provides the information documentation to the requesting party, but also the requesting party may accompany the requested party, provided they obtain the consent by the visited exporter or importer. So I think we do not only need to be careful with our operations on originating goods that are traded between the parties or goods subject to preferential tariff treatment, but also to any goods traded between the parties. We need to keep records. We need to take reasonable care when conducting our operations. And I think this is something we need to keep in mind.
Thank you, Fanny. I don't know if you would like to add something about what the Mexican customs authorities have done in terms of the implementation of these chapters.
Yes, well, there's two areas: the Ministry of Economy and the Tax Administration Service. The Ministry of Economy published the uniform regulations. The Tax Administration Service, through the Ministry of Finance, published the two sets of regulations. They were published the 30th of June. And these sets of regulations are the Customs and Trade General Regulations, which are Mexico's administrative customs regulations. They were published in the official bulletin on June 30, as well as there's a USMCA regulations, which used to be Nafta regulations. They were amended in order to adapt to changes from Nafta to USMCA. But also the Ministry of Economy started publishing advanced information before the entry into force of USMCA. They created a website where they have been publishing information that's relevant to on USMCA, including the text of the USMCA legislation, regulations related to its implementation, application, reports, guidelines, presentations, frequent asked questions, and they developed a couple of tools also to help understand USMCA. There's a calculator and that helps you determine origin, whether your goods meets or not the rule of origin. It's kind of simple, but it takes you step by step through questions in order to find out whether your good qualifies or not. It has also undertaken a series of workshops and webinars. They are all public in the website and also in the Facebook page of the Ministry of Economy. Also, the Ministry of Economy created a help center where anyone may pose questions with regards to USMCA, and questions may be posted by mail, and the Ministry of Economy delivers a written response by mail within 24 hours. And with regards to the Tax Administration Service, they also created a website for relevant information, frequent asked questions, and inquiry points. And in this case, with the Tax Administration Service already has a help center, not specifically for USMCA, but they have a help center for questions, and they receive questions through telephone, by mail, on the web page, by chat, and the links are all at the web page of the Tax Administration Service. And recently, the head of the Tax Administration Service instructed to reactivate a Customs Operation Committee, which I think is an important option or mechanism to have these frequent contacts with the customs authorities, both to raise concerns, matters, questions, and to seek a resolution, to seek a response from the authorities. And in this Customs Operations Committee, which used to work some years ago and will be reactivated soon, chambers and associations that represent traders participate, and they may raise proposals, either regulatory to improve operations, or they may pose specific cases to solve day-to-day problems.
Thank you very much, Fanny. And now let's talk with our private sector. Let's talk to Federal Express, to Adrian. We are very interested, Adrian, to know how would you compare cross-border e-commerce under Nafta and under USMCA? What would you think are the main benefits and pain points for e-commerce, which is, you know, a trending topic right now, and express shipments under USMCA? And what would be, in your opinion, the roadmap ahead, Adrian?
Thank you, Turena. Can you hear me well? Okay. Well, first of all, thanks for the invitation and for having me. It's an honor to be here with distinguished mentors, government officials, and colleagues as Fanny, Ricardo, and you, Turena, and of course, Mr. Jonathan Chait and John Leonard. Thanks for having me. So, how would we compare cross-border e-commerce under Nafta and USMCA? Let me tell you. Before USMCA, during the times of Nafta, there was no differentiation whatsoever between regular cross-border general trade and cross-border e-commerce. Pursuant to at least two models of the World Customs Organization's, two models of the WCO, which included the immediate release guidelines for express consignments and the trade facilitation agreement, the USMCA brought together a differentiated lane for customs clearance of a large portion of the business to consumer transborder e-commerce. I must say that express delivery companies have become the bloodstream of e-commerce, especially of business to consumer e-commerce, to the extent that USMCA now devotes Article 7.8 to regulate certain aspects specific to the clearance of express shipments from customs. The USMCA provides several facilitation measures seeking to expedite the passage through customs of express shipments, many of which, in the case of Mexico, already existed before or had been agreed as part of the WTO Trade Facilitation Agreement. But the key difference before and after USMCA is that as part of an international agreement, these differences now become part of the Mexican legislation rather than being only one foggy WCO recommendation or a unilateral benefit given at will by the government or by customs. They have now become mandatory. And this is a big step forward in terms of security for investments and the rule of law. Talking about benefits and pain points for e-commerce and express shipments, well, there are several or many items to highlight, but I will concentrate in only 4 of them. The first one is that under USMCA for express shipments, each country shall allow for the periodic assessment and payment of duties and taxes applicable at the time or point of importation. This is, the shipments may be imported into the country and duties and taxes shall be paid to the taxman at a later time. While this mechanism already exists in the US, it is new to Mexico. So new that it has not been implemented yet. And this is a shortcoming and a big area of opportunity pending solution. And I'm glad to say the express and e-commerce industries have begun a dialogue with the Tax Administration Service and the Ministry of Finance with Hacienda towards conjointly designing how to implement this pending USMCA provision. So at the same time, it's a benefit, and a pain point. The second one would be that the USMCA sets forth minimum floors for exemption of payment of duties and taxes. They are at least, in the case of Mexico, $117 for customs duties and $50 for taxes. In Canada, in a similar bifurcated scenario, you have 150 Canadian dollars for customs duties and 40 Canadian dollars for taxes. And in the case of the US is $800 flat for duties and taxes. And whereas it is true these thresholds existed before, the novelty, at least for Mexico, is the fact that before USMCA, they were a unilateral facilitation measure. And it is also true that now, after being set forth in the agreement, they have become law. And here we enter again into the field of opportunities. In Mexico, before USMCA, shipments valued at $50 and up to $1,000 used to pay a flat fee of 16%. This is equivalent to the IVA or the value added tax. Now what happened? On July the 1st, seamlessly, with implementation of USMCA, Mexico raised this flat import tax rate in 6.25% to 17% and in 18.75% respectively to new rates of 17% for shipments coming from either the US or Canada and 19% for shipments coming from the rest of the world. And whereas this measure is unilaterally coming from the Tax Administration Service and not tied to USMCA, it entered into force simultaneously. It does affect many shipments coming from the US and Canada, and it increases the taxes they pay with respect to what they paid in the times prior to USMCA. This is, it was cheaper to make this kind of operations under Nafta. And the paradox is Mexico enters USMCA increasing taxes for many eligible shipments valued between $50 and $1,000, and rolling back those taxes to pre-USMCA levels is indeed the area of opportunity that we would like to seek. The third item in the field of opportunities is that USMCA sets forth that each party shall adopt or maintain procedures that apply fewer customs formalities than those applied under formal entry procedures, to shipments valued at less than 3,300 Canadian dollars and 2,500 US dollars in the case of the US and in the case of Mexico. This provision, which is set forth in Article 7.8, is intended to regulate express shipments. Notwithstanding, in Mexico, the rule currently governing the simplified clearance of express shipments, precisely, which entered into force on the same day USMCA was implemented, applies only to shipments of up to $1,000. So, in our view, and even when the spread between the $1,000 and $2,500 may be complied with elsewhere, the fact is that the rules regulating express shipments do not comply or are not in full compliance with the agreement. At the moment, we're trying to maintain a dialogue with authorities in both Mexico and the United States, trying to get Mexico to adjust this implementation measure in accordance to what is actually set forth in the agreement. And there's one fourth item worth noting. This refers to the certification of origin. As Mr. Leonard correctly pointed out, USMCA sets forth each party shall provide that a certification of origin shall not be required if the value of the importation does not exceed $1,000. However, in practice, both Canada and the United States have unilaterally set up higher thresholds for requiring a full mode certification of origin, which are respectively 3,300 Canadian dollars and $2,500 in the United States. This is the agreement sets forth $1,000, and this is used by the Canadian and US governments as a floor because they actually provide a better or a higher facilitation measure. By doing this, they are giving a higher administrative benefit to their importers, and by extension, they are giving a benefit to the exporters of the other countries, including Mexico. So what we are basically asking the Mexican government is to consider doing the same and granting this better facilitation measure akin to those granted by the Canadian and the US governments to the import-export community trading with Mexico. This would be, Turena, in a nutshell, the single most important benefits and pain points for cross-border e-commerce under USMCA. And you asked what comes ahead, what's next? Well, we hope through the current dialogue to obtain first a speedy implementation of the periodic payments provision of USMCA. Second, a sensible adjustment of the import duty and tax rates applied to this kind of shipments. Third, a sensible adjustment to the rules governing clearance of express shipments in Mexico to adequately match the provisions of the agreement in benefit of cross-border e-commerce. And fourth, get Mexico to unilaterally grant a facilitation measure on certification of origin that can be equivalent or akin to those granted by the Canadian and US governments. In a nutshell, those are the benefits and the pain points of implementation of USMCA for e-commerce and by extension for express deliveries.
Well, and I mean, very, very useful information, and talking about the practical view and the paradox that you are facing. And I mean, it's great for us to know and for you to share these pain points that could be, you know, a challenge and an opportunity for the region. So thank you, and good luck with that.
Thank you, Turena.
And Ricardo, spicing the you know, this very interesting talk and very interesting panel, we want you to we want you to talk about the new labor chapter in the USMCA. I mean, a lot has been said about this chapter, and of course there are a number of positions and you know, concerns. Could you share with us some of its main features in particular? I mean, how would it impact Mexican and foreign companies established in Mexico?
Thank you, Turena, and thanks to the US-Mexico Chamber of Commerce. It's great to be here, and of course with my dear friend Turena. It's difficult to summarize in some minutes what the labor chapter is about. So let me put my professorial hat and give you some short slides of what is this about. And let me start with a main theme, which is the labor chapter is one of the chapters that, if not, I mean, Mr. Leonard talked and Adrian and Fanny talked about a lot about the practical aspect of this cross-border trade. But this chapter, I think, is the most intrusive chapter that affects companies individually. I mean, of course, every company has to be aware of what the USMCA says, what the USMCA provides for. But this particular chapter has some features that really touch on some particular or companies should be aware of. So let me put my hat in and try to be, with this help me on being succinct on the chapter. I hope that everyone now can see the presentation. What is this chapter about? Of course, this chapter comes from the Nafta. The Nafta had remember when the Nafta was negotiated, there was this side agreement negotiated and signed when the Democrats came into power. It was two side agreements, one related to labor and one related to environment. So this is the background. And basically what the Nafta and the USMCA said is you have to comply with your laws, with your labor laws. In a nutshell, basically what both agreements provide for is that you have to enforce your labor laws in a way sustained and recurring. You have to systematically comply with your labor laws. And this is where they started to change a little bit. The USMCA has a more wider scope of obligations related to labor. And basically I just put some of them just to highlight these disciplines on. This is important, the first one, which is the freedom of association and effective recognition of the right to collective bargaining. But it also provides on the elimination of forced and compulsory labor, and especially narrows on child labor. It also provides for the elimination and discrimination in employment and occupation, and also of promoting, or the goal of promoting, equality of women in the workplace, which is a very important provision. It has provisions against violence at risk of violence against workers. It has special provisions that NAFTA didn't have about migrant workers. And of course, it has some provisions that there should be acceptable conditions of work with respect to minimum wages, hours of work, and occupational safety and health. So this is the framework where you work on the labor side. And basically the chapter says, okay, you have to comply with your labor laws. But then the chapter goes a little bit ahead, goes a little bit forward. And this is I think, the interesting part. And I prepared this chart because I think it highlights what is important at the end. In terms of dispute settlement, if one country, if Mexico, Canada, or Mexico does not comply with these labor provisions or does not enforce its laws on these disciplines, then Mexico could be subject to the general chapter. So it could be subject to a state-to-state dispute settlement. And that is the same way that the Nafta provided for. Fortunately or unfortunately, under Nafta, there was no dispute between Mexico, US, or Canada. Basically, the dispute settlement chapter was never used. But there comes the specific part, which is USMCA is unique, and not only unique with respect to Mexico or with respect to, I think unique with respect to any trade agreement in the world, which is USMCA provides for a mechanism called facility-specific rapid response. And that is a specific mechanism which targets companies specifically, and not only companies, facilities specifically. And what it aims about is to address a possible denial of rights regarding one obligation now, which is the freedom of association and effective recognition of right of collective bargaining. This is the only obligation that is subject to this mechanism. But there is a back door, and that's why I always call it the back door, because there is a provision in the agreement which provides that if, for example, the United States initiates a case against Mexico on child labor, and the United States prevails, and there is a determination that there has not been an enforcement of Mexican child labor's laws, then this child labor comes to could be subject to the facility-specific rapid response. So what I always tell people is that not only is this provision, for now is this one, but it could be expanded. So as you have it, is you can basically use the Nafta, use the USMCA to target these companies. So target a specific company and a specific facility of a company. So let me tell you some features of this mechanism. First of all, it's bilateral. It's Mexico-US, Mexico-Canada. It doesn't provide a mechanism between the United States and Canada. It's only that. It's supposed to be both ways. That is, Mexico can initiate, US can initiate cases against Mexico, and Mexico can initiate cases on this against particular facilities in the United States. This is on paper. In practice, there's a footnote that makes a little bit difficult for Mexico to use these mechanisms against US companies. But if I have time, I will get to it. So it applies to what they call cover facilities. Which are cover facilities? Is a facility which produces goods or supply services traded between Mexico and the United States, or Mexico and Canada, and that, sorry for a typo, that competes in the territory of the party with a good or provides us or service. So it basically, the scope is very wide, because it's basically any traded good or any good that competes is subject to the system. And, and it also provides for certain sectors. There's a list of sectors which you can apply. But if you read the language, and for us lawyers, language is everything, and you can say the scope is manufactured goods include but not limited to. So it's an illustrative list. So these sectors are subject to this mechanism. And what does these mechanisms do? And I will get to that. The obligation, again, is only with respect to the right of free association and collective bargaining. So what is the system about? Basically, one party can ask for a denial of rights and initiate a procedure against a specific facility of the other country. So you can say that a specific facility in Tijuana of X company, and it's important to highlight this, Turena, because it's not a US company or a Mexican company. It can be company of it can be a Japanese company established in Mexico, where you can initiate a system and you can argue that there has been a denial of rights with respect to free association of labor laws, or that the laws have not been complied with in that specific facility. And this is what, and I hope I can convey this uniqueness, because this is the first time that there's a dispute settlement system that targets a specific facility of a specific company. So you can initiate a case against that specific company. And basically, I don't want to drag you into the process, but basically, first of all, there's some discussion of dialogue, if you want to call it, between I guess, Mexico and the United States, of course, involving of course, also with the company involved. They discuss about how can they solve the problem? How can stop this denial of rights? How can they remedy this denial of rights? But if at the end, either the US does not agree that there has not been, if the US considers that there still is a denial of rights, the US can request a panel. And this is another important feature. This is a panel of labor lawyers, not of trade lawyers, that will determine whether they have rights by that facility. And of course, there will be a determination which says whether there has been Mexico or there has been or not in that facility compliance with the freedom of association obligation. And that takes me to the last part, Turena, which is what are the sanctions? What are the remedies? No? At the end, the remedies is that, and this is important for companies because you could be subject to penalties or suspension of preferential treatment of goods coming or services coming from that facility. But if you do it again, they could expand this not only to the covered facility, but to the facilities that are owned or controlled by the same company. And if the violation is still going, then you can even go to denial of entry of goods from that company. So I hope I can, I tried to give the highlights to Rena, but basically this is how the system, there has never been such an intrusive system in terms of, aside from trade, with respect to labor laws. And I will leave it at that if you want to ask another question.
Well, thank you very much. I mean, this is very enlightful, Ricardo, and of course it is a complicated subject to address with a lot of background, as you clearly share that with us. And of course, this is the first time that such a labor non-compliance, perhaps, could be actually have a consequence in trade. Consequence in trade that could actually have a lot of risks. So a compliance program could be very useful for not only, as you mentioned, US or Canadian companies doing business in Mexico, but for all companies doing business in Mexico with the purpose of exporting their final products to the US market. So talking about something that has been a concern for many of us. Bearing in mind the election atmosphere, Ricardo, there are some media reports which suggest that the U.S. may soon initiating, labor cases against Mexico from a company established in Mexico. Is complying with the Mexican labor law enough, or to prepare for this scenario, or what would you recommend?
Well, this is important to highlight, Turena, because companies need to be, of course, you mentioned that, and it's important to have a compliance program of labor laws. But again, we are in territory incognito because we don't know how the system will work. And at the end, there could be very well cases. I guess the US, if the US wants to initiate a case, it could be a very well structured case and very well sustained or founded case. But if not, but there are some that could suggest that this could be a tool for protectionist measures. And it could be abused if you want to just stop a company from exporting to you, a competitor from the US to Mexico. You can target it on labor laws. Some scholars have suggested that this may become the new dumping. So there will be labor dumping in some way. But at the end, I think it's premature. I think we need to see how it develops, how it evolves. But I think it's something that we have to keep in mind.
Absolutely, I totally agree with you, Ricardo. Let us be aware of how this would be implemented. And talking about the rule of law, which is also a big concern for foreign investors in our country and in the region, what is different in terms of investment protection from the previous NAFTA investment provision, in particular with respect to access to the investor state arbitration? Can you talk a little bit about that?
Yeah, I will be brief since we plan to cover this as well. Chapter 14. Basically, what is that? What is it about? And I will be very brief and just to give you a very quick glance of what the chapter is about. First of all, there was an update of substantive provisions. Based on the experience on cases of previous cases, there was some elaboration by the NAFTA, by the USMCA parties on the basic structure of the substantive provisions, such as minimum standard of treatment, discrimination provision, expropriation, indirect expropriation. So the basic obligations on investment. The second one was the process was improved. There was there are some provisions of burden of proof. Of course, transparency was also improved. And I think the most important part, which I think actors or our audience will want to hear, is there is a differentiation between sectors. So there will be some sectors, in particular oil and gas, electricity, telecommunications, transportation, and infrastructures, and government contracts related to those sectors, that will be privileged to have what we call full ISDS, which is all the substantive provisions of the chapter. They could invoke them. And this is a big issue because there will be some companies, for example, in sectors that are not within those sectors, that can only invoke the skinny ISDS, and I put it in quotes because it's not my term, it's some term of art, which only allow of claims to invoke claims related to discrimination or direct expropriation. So there are some claims, there are some substantive provisions that are left out, and I just give you two examples. First of all, minimum standard of treatment, which goes against acts that are arbitrary, capricious, or by a government. And the second one is what we call indirect expropriation, which is actions by a government that have the effect of an expropriation. So again, just remember, Turena, that when the NAFTA, the USMCA was originally, and the negotiations started, the US didn't want this chapter, didn't want ISDS. The US, and in fact, there is not ISDS between US and Canada. So this was a compromise of getting some full, what we call some full ISDS, but there were some companies that are left out.
Yes. I mean, a lot of politics involved. You know, a sovereignty, spirit in terms of why this should or should not be included in the USMCA. There's one question from the audience talking about what are the economic consequences to trigger these labor procedure that you recently explained, Ricardo.
What are, sorry, I didn't hear.
And if there, what are the economic consequences of triggering this labor dispute, this labor dispute that we were talking about? I mean, well,
remember the dispute is triggered by a denial of rights with respect to the obligations regarding free association. Of course, there will be some companies that could be affected just by the mere fact that you are initiating a case. And I don't know if that was what the question referred about, which is, we don't know. And I think, as you correctly anticipate, there may be an incentive by the US administration to initiate a case before the elections. We don't know. Or remember that even aside from who wins, the Democrats have a very labor progressive agenda. So there might be, this chapter may be used more than we think about. But up until now, we don't know. I mean, we always say that something's going to be big, and it's not big, and there was something small, and it turns out to be big. So I refrain from making any forecast.
Well, the challenge is there, and of course, I mean, this was an excellent insight, Ricardo. Thank you very much for your participation. Thank you very much to Fanny and to Mr. John Leonard and Adrian. I mean, I think that the audience is pretty grateful with all of you. We have received very, positive comments with respect to the insight that you have, that you have shared with us from the U.S. Authority perspective, from the private sector, from the Mexican perspective in terms of customs and trade facilitation, new compliance, these new challenges in terms of the labor requirements, the implications, how we can use the USMCA also to protect foreign investment. And this is, I think, that the one of the most, interesting talking points. I mean, how can we benefit from this agreement? Thank you very much. And I think that we had exceeded a little bit our time frame. So I don't know, Clementina, if you would like to add something else. I mean, I'm very happy, and I am very proud of the experience and the knowledge that we have shared today.
Yes, there's a lot of information. We can still here talking for hours and hours, but what I'm gonna do from my side is to our members, if you have any questions, you would like to have the information of our panelists, please let me know, send me an email, and I will be more than happy to connect with them. They are experts in the topic, so I'm sure that they will help your company to solve any question that you have regarding this bilateral trade and the USMCA. For now, I hope that you enjoy this webcast as much as we did. I will keep you informed of our future webinars. And well, please do not hesitate to contact me, or if you have questions or there's something that we can help or do for your company or for you. Thank you to my team. It was great working with you. So please take care and stay safe.
Thank you.
Bye.
Clementina, just before we end it, there's a request if we can all share our emails.
Sure. Yeah. I will share your emails, and also this webcast has been recorded, so we are gonna share the webcast through our social media channels. So people who cannot connect this morning, they are gonna have the benefits of this conversation.
Thank you very much.
Thank you to the US Chamber. Thank you very much.
Good day, everyone.
Bye.
Thank you. Bye-bye.